Hey everyone. So last week on May 21, USCIS released a new policy memo that impacts adjustment of status in the United States. Now, there's a lot of confusion over this and a lot of questions, so this video is put out with the intent to provide some information about it, with the understanding that we're still waiting on USCIS to release more information so we know exactly how they're planning to apply this memo. As a little background, adjustment of status is where someone in the United States is applying for their green card. So that can apply to a lot of different people that are in the United States as refugees or asylees, maybe individuals that have an employer or a family member petitioning for them, maybe people that are victims of crime and are now applying for their green card. So there's a lot of circumstances in which you may do this. And this memo is saying that people who are applying for adjustment of status may not be able to do so. Instead, they should pursue consular processing unless they fall into a certain category of people where USCIS deems that immigration should exercise its discretion to allow someone to adjust status in the U.S. instead of process through the consulate abroad. So the alternative to applying for your green card in the United States is to do a process known as consular processing, where you have to leave the U.S. if you're already here, or if you're not in the U.S., then you would just stay where you are and undergo it from another country. But it requires that you go through an embassy in order to be issued an immigrant visa to enter the U.S. as a permanent resident. So this is really going to impact people that are already in the U.S. and are applying for their papers here. Going abroad can create a lot of issues, not just that it takes a lot more time and it may unravel a lot of work that you've already done, fees that you have already paid, but also that once you depart the US, you may trigger certain bars that wouldn't apply to you if you're just adjusting status in the United States. Most notably, if you're in the United States out of status, maybe you have overstayed a visa or something of the sort. If you leave the US, you may trigger an unlawful presence bar, which means that you would have to, in most cases, apply for a waiver of that bar. And that can cause delay of many years before you're able to come back on that immigrant visa. This memo could really severely impact a lot of cases. So the question that is first put before us is, who is this going to impact? And that is probably one of the biggest questions that remains unanswered. So it seems from the memo that most clearly it's going to apply to people that are seeking adjustment of status under Immigration and Nationality Act, Section 245A. And so that is generally for people that are applying through a family-based petition or an employment-based petition. So that is the vast majority of people that qualify for adjustment of status. So for example, if you are married to a U.S. citizen and your U.S. citizen spouse is petitioning for you, or your permanent resident spouse is petitioning for you, then it would directly impact that sort of case. A question remains as how far outside of that scope does it go? It's unclear right now. We do expect USCIS to release more guidance. I would say it is probably unlikely to impact as much other types of cases, other types of adjustments. So for example, if you are an asylee or a refugee, or if you have U status or T status, I think it's less likely to impact you if you're now applying for adjustment of status. But again, we're waiting to get more directive about exactly who it applies to. If it does apply to you, what does that mean? Well, it seems to mean that you have to show that USCIS should exercise its discretion to allow you to adjust in the United States. In other words, you have to show that you are deserving of this benefit. So that may require showing that you have strong family ties, that you've been working consistently and legally in the United States, that you have been properly filing your tax returns, that you provide economic benefits to the community, that you volunteer, whatever it might be. It's really specific and unique to your circumstances, but it does require bolstering and building up that kind of proof. Now, if you have negatives to your case, then it's something that you have to address right at the onset, and then you need to try and offset those negatives. So some obvious negatives may be that you have criminal history, even if it's been expunged from your record or it's been done with for many years, it's still something you need to address. Or perhaps you filed your tax returns late, or maybe you filed them incorrectly and you have to go back and amend those. So those types of negative factors, overstaying a visa, any immigration fraud in an application, those are things that you really need to look closely at and make sure that you can offset any negatives there. Moving forward, what should you do? If you have a case pending, what should you do? And if you're about to file a case, what should you do? So for our clients, we are advising, for right now at least, that if there's a case pending, that we don't file anything yet. We're going to wait and see how USCIS starts to implement this. If we start to get requests for evidences in the mail, notices of intent to deny, any other kind of correspondence from USCIS. And depending on that, we will start to respond to those for pending cases. So though we're not suggesting that anything be filed at this time, there is a list that we've put together, and we're attaching that to this video, of the types of documents you should go ahead and start gathering in case it is requested or is needed later in the process. Now, what if you haven't yet filed anything, but you're about to? So for those kinds of cases, I would suggest going ahead and putting some discretionary evidence in the packet so that it's something that an officer can easily look at. So again, that's that kind of evidence that we talked about before and is in the link below, where you're showing that you're involved in the community, that you're filing your tax returns timely, that sort of thing. How likely is this to proceed? That is a big question. Certainly there are lawsuits that are going to be filed very soon to challenge this. I think that there's a very good argument that this memo is a violation of the law and will not be upheld. But unless and until that happens, it is best to prepare your case moving forward. So I would suggest that people that have counsel, you speak with your attorney about it. If you are our client, of course, we'll be reaching out to you. And also you can reach out to us at any point to schedule an appointment or to contact us with questions that you specifically have about your case. If you don't have an attorney or you're self-representing, I would suggest that you at least consult with an attorney about your specific case to see what is likely to happen and what they would suggest for you. Because regardless of how this ends up being applied, it's best to make sure that you have a game plan so that moving forward you can make the best choices possible. We will continue to keep you informed on our social media pages. If you have any specific questions, please reach out to us or post them with this video, and we'll be happy to get back to you. Thanks so much.